and welcome to the Galliher Law Firm. The Galliher Law Firm handles slip and fall cases. Let me tell you a little bit about what these cases are about. You go to your local supermarket, you go through the produce department, somebody has deposited 3 or 4 grapes on the floor, you don't see them, your left or right foot impacts them, it slides right off from under you, you fall heavily on your back and your head and your neck. A lot of people don't realize that fall incidences actually cause more deaths in the United States than virtually any other cause. So never doubt for a moment that you can be very seriously injured in a slip and fall incident. If this happens to you at a supermarket, department store, retail outlet, restaurant, wherever it may be, first, don't attempt to get up too quickly because you might have been seriously injured and you might further injure yourself. Make sure that the employees respond to the scene of the fall. Make sure that photographs are taken of the substance that you slipped on. Make sure that witnesses in the immediate vicinity are identified and that their contact information is taken down by store employees. Make sure the store fills out a report concerning the incident and make sure all of the evidence of the fall is preserved. Now, you may not be of a mindset at that point in time because you're injured. But if you can remember these things, it's very important that you make sure that they are followed whenever you fall. In Nevada, if you fall in a supermarket, a retail outlet, a restaurant, it doesn't necessarily mean that the restaurant, supermarket, retail outlet is liable for your fall. You have to show actual or constructive notice of the condition which caused the fall in order to win your case. By actual notice, what I mean is either a store employee saw the spill or the fruit on the floor and failed to clean it up. Very unlikely that you'll get that testimony in your case. If the condition was caused by a store employee, let's assume a store employee, for example, is mopping the floor, doesn't put up warning cones, and you slide on the water and fall, that's also actual notice. That means there's liability on the part of the store, the supermarket, the retail outlet. There's also something called constructive notice. That's much more difficult to establish. You have to be able to show that the store policies of maintenance and inspection of the floors is unreasonable. Usually that means that the store does not conduct inspections more than an hour apart of their floors. If they do conduct inspections every 15 minutes, 30 minutes, it's going to be very difficult for you to prevail at time of trial. More recently, the Nevada courts have developed what's called the mode of operation theory, and that pertains to situations in which we have self-service. For example, a Taco Bell or El Pollo Loco, where they have a salsa bar, a supermarket which sells water that you can dispense into water bottles and carry throughout the supermarket, a restaurant that's self-serve as far as the drinks are concerned. Same thing with the convenience store. These types of operations can enable an attorney who properly prepares the case to get a mode of operation jury instruction, which means basically that the entity is on continuous notice of the condition which caused the fall. It makes it much easier for you to prevail at trial.